Hi, everybody. Welcome back. It's the evening of Sunday, August 23rd, 2020. This is a case review for Sailab versus Canada. It's a pretty recent case, actually, in federal court, FC 773. So to reiterate again, I'm not a lawyer. I am taking an immigration tribunal class. I've been doing this for practice. I wrote my RCIC entry exam on August the 9th. Hopefully I passed, and that's why the reason why I'm doing this. All right, so Sailab was a member of the Afghan military, and he was in the United States for military training, and he made his way to the Canadian border, where he tried to claim in Canada asylum because he was afraid of going back to Afghanistan. The minister went through his history and discovered that he was actually responsible at one point in time for transporting Taliban prisoners, and that's why he was actually scared to go back, because apparently his unit was responsible for the torture of some of these prisoners. And therefore, because of that, he was deemed inadmissible according to IRFA Section 35. So that went through the immigration division, and he had appealed. And the evidence that the immigration division brought forward wasn't really pertaining to him, and that was the whole basis of the appeal, actually. So the immigration division brought forward three separate documents, accepted documents, as the general behavior of his military unit, what happened at some of the military bases, and what had transpired. So Sailab appealed to the federal court, and this case is pretty recent, and very importantly, it confirmed two things. One is the standard of review under Vavilov, which was a very recent case back in, I think, November. And the standard of review for reasonableness, I can never pronounce the word, is that the decision must be an internally coherent and rational chain of analysis and must be justified in relation to the facts and the law. It must also bear the hallmarks of reasonableness, justification, transparency, and intelligibility. And that's directly from Vavilov. The burden is on the party challenging the decision to show that it's unreasonable. And in the next paragraph that I'm showing, what were those three documents? And they're very general documents, and that's the whole basis of the immigration division's decision. So, like I said, there's two major confirmations of this case. One was Vavilov, and this case was pretty recent. The second one was another case, a little older, and actually I've got the slide that maybe in a slightly the wrong order. And that case was Ezokola versus Canada. I think I pronounced that correctly. And that also went all the way to the Supreme Court of Canada too, back in 2013. And it set out the legal framework for exclusions under refugee acceptance, section 1FA. And in my book, which I always refer to, if you're also a student, you can reference that on page 13. So, and actually this particular case is also in the Green Book and the Eamon's book too. So refugee exclusions is basically, so an exclusion. Now, even though it was said that under Vavilov, the onus was on the appellant. Ezokola has this framework, and basically from 2013, it laid out the framework as follows. It's not enough for a claimant to simply belong to a group that commits criminal offenses. It is necessary for the claimant to voluntarily and knowingly make a significant contribution to those crimes. The following factors should serve as a guide. The size and the nature of the organization, and in this case is the Afghan army, so it encompasses the entire country. The part of the organization which was the refugee claimant was most directly concerned, and since he had transported these prisoners, you know, he was deemed inadmissible. The refugee claimant's duties and activities within the organization, and again, he was transporting, fix this, the refugee claimant's position or rank, and in this case, he was a driver, the length of time the refugee claimant was in the organization, and then lastly, the method by which the refugee claimant was recruited. And I believe he had volunteered, if I'm not mistaken. So up to this point, it seemed like the immigration division, nothing had a fairly strong case. And this is me speculating. And there was a quick blurb about whether he knew or not. So in paragraph 18, the immigration division, it was stated, failed to establish whether the applicant would have become aware of the abuses of him driving the prisoners around. So that was a major concern of the trial judge, in that when it came to the judgment, you know, the evidence provided was, you know, were the three documents, was that there was systematic use of torture, but what the immigration division failed to establish was, as Mr. Sailab personally was involved in that, aside from driving those prisoners, and whether or not, and they failed to prove whether or not he knew that they were going to be tortured. I think that was stated in another paragraph. So this case is important because for those two reasons, because Vavilov was a framework for reasonableness was used, and secondly, the other case from the other earlier case, Ezokola from 2013, that framework was still applied even now. And this case was actually brought forward, or actually settled just last month in July 2020. So the other piece that I found interesting was that there was another legal concept, a standard of burden of proof, in that when I did my immigration class, I studied 4 different burdens of proof, levels of proof: suspicion, reasonable grounds, balance of probabilities, and beyond reasonable doubt. Where in this particular case, and there's a URL that you see here, there's another level of proof, burden of proof, and it's called serious reasons for considering, which is, according to that document, less than the balance of probabilities. So, you know, I'm still not clear. That's the first time I've come across this. So in my mind, it's less than 50% because balance of probabilities is greater than 50%. And I'm guessing it's more than reasonable grounds. So this is something I have to do a little bit of research on. So thank you very much. That's my case review for Sailab versus Canada. Again, it confirms Vavilov versus Canada, and it also confirms that the legal framework for Ezokola versus Canada is still in force. And Ezokola versus Canada has a 6-point guide into whether or not a person should be deemed to be to have committed those serious crimes against humanity in Section A35 of IRPA. Thank you very much. Hopefully, I'll get back to the Excel stuff soon. I've been dying to, just been so tied up. So thank you very much, and I'll see you all soon.